Hi and welcome back. Today I'm talking about adverse possession of land, or acquiring land by adverse possession. But if you're new here, please do like, subscribe and hit the bell icon so you receive notifications of new videos. So whilst we were wandering around on the topic of land, pun intended, I'm going to talk about the adverse possession of land. Now, as I said in one of my previous videos, most land in the UK is now registered to somebody as an estate. But some of you will know that there are little slithers of land here and there that remain unregistered, although they are few and far between these days. In short, adverse possession means you can acquire a piece of land that didn't belong to you beforehand. The important date to think about in terms of adverse possession is 2002. This, of course, I'm referring to the Land Registration Act of 2002. The Land Registration Act 2002 came into effect on the 13th of October 2003 and introduced a new scheme for the acquisition of registered land by adverse possession. Under the scheme, there is no limitation period for the recovery of a registered estate or rent charge. Adverse possession does not, in and of itself, bar the registered proprietor's title. So by way of background, the owner of an estate in land is not obligated to make use of that land, and merely by neglecting the land, he will not lose ownership. On the other hand, if the land is adversely possessed for the required period of time, he can lose his title to the estate. Essentially what happens here is if the land has been adversely possessed for the requisite period of time, the adverse possessor will gain better title to the estate than the original title holder. This is still the case even if the adverse possessor was a trespasser in the first place, although it's important to note that this does not apply to residential premises. See the Legal Aid Sentencing and Punishment of Offenders Act 2012, Section 144. So how is it, you ask, that one goes about adversely possessing a piece of land? The requirements were neatly set out in Buckinghamshire County Council and Moran in 1990. And the requirements are quite simple and twofold. Firstly, the adverse possessor must be in factual possession of the land, and he must be doing so with the requisite intent to possess that land. And these requirements were subsequently confirmed in other court cases. So dealing with factual possession, as many other things in law, it's a matter of degrees. The adverse possessor must demonstrate a sufficient degree of control over the land and that he has been able to deal with it as any other occupying owner would have, and that no one else has done so. This was established in a case involving a farm where the grazing license had expired, but they continued to farm that land for the next 12 years, and it was accessed by a padlock gate. So again, it demonstrated factual possession of the land. Essentially, nobody else was using the land, but they were using it as if it were their own. Another popular example is by putting up fences around the land. Many of you will have heard that if you put a fence around land for the requisite period of time, and you are dealing with it as though you were the owner and no one else is accessing it, but you are dealing with it as though any other occupier would, that is likely to show the degree of physical control of the land that it requires. And as in the example with the farm, where the only access is through a padlocked gate, essentially the people that can use the gate and no one else has a key, they would be the only ones in factual possession dealing with the land, and no one else can access it. An example of where this was not the case was where children were allowed to play on a piece of land whenever they wished. Just because the children were playing there, it did not demonstrate the sufficient degree of control over the land to establish adverse possession. They were deemed to be merely trivial acts of trespass rather than factual possession of the land. It's also important that the actual possession must be something that the paper owner could, with reasonable diligence, discover themselves, as in the Limitation Act. Similarly, having permission from the paper owner naturally cannot be adverse. After all, it's adverse possession to the paper owner. Moving on to intention, there must be an intention to adversely possess the land. In one such case where this was held not to be the case, there was a 14-year-old boy who was grazing his cow on the land. Clearly, he didn't intend to adversely possess the land. He was just taking his cow there. Although it is just a requirement for an intention to possess rather than dispossess, which is not quite the same thing. Similarly, it's not necessary that the adverse possessor intends to own the land. It's only necessary that he has an intention to possess it for his own benefit for that period of time. Although, as I said before, if the adverse possessor believes that he has permission from the paper owner, this will defeat any claim that he makes for adverse possession. The requisite period for possession with intent of registered land is now 10 years. So there is clearly a difference between establishing adverse possession on registered land before and after the Land Registration Act 2002. As a bit of a tip, think of the date from which the adverse possession is said to have begun, add 12 years to this date. If this brings you to before the 13th of October 2003, then the old rules are going to apply. So for example, bringing one date just before that, take 1990 plus 12 years brings you to 2002. That means it's just before this date. That means that the registered owner would hold the land on trust for the adverse possessor under Section 75 of the Land Registration Act 1925. If, on the other hand, the date that you get to brings you to 2004, then the new rules are going to apply. So in essence, the adverse possession of registered land after 2003 is not based on limitation of actions. Instead, it is the person adversely possessing the land to take positive steps with the land registry to register title. Once the adverse possessor of a registered piece of land wants to register title, he would make an application after that 10-year period. On such application, the land registry is going to notify the title holder and anyone with a beneficial interest in the property. This is usually a mortgage company or someone else with a charge over the land. And they are then given 65 working days to submit an objection to this application. If no such objection is received, the adverse possessor is going to be registered as the title holder. If there is such an objection, the paper owner is given 2 years in which to remove the adverse possessor or to give permission. In the event that this doesn't happen, the adverse possessor can make another application to be registered as the title owner. If such an application is successful, then the adverse possessor will become the title owner and it will displace the original proprietor. Contrasting this with the adverse possession of unregistered land, this is the same today as it was before 2002, and this is indeed based on the limitation of actions. So what does this mean? Well, ultimately this means that the paper owner has 12 years to remove the adverse possessor, after which such actions are time-barred and title to the land is extinguished. And finally, there is a requirement that the adverse possession does not violate Article 1, Protocol 1 of the European Convention on Human Rights. But this in itself would warrant a whole separate video. So I hope this has been a useful insight into adverse possession and what it's all about. As always, there will be lots more questions, lots more details that I haven't managed to cover, as this is just intended to be an overview video. So please do share your questions and comments down below and I will check as many as I can. Please also check out my Patreon page, my channel memberships here on YouTube, my Facebook group, my Instagram profile, my TikTok page. I'm everywhere you want me to be. I'll see you there.